evidence you will give will be the truth, the whole truth, and nothing but the truth? If so, raise your right hand and say, so help me God.
So help me God.
Thank you. Mr. Salgazana?
Thank you, Chairperson. Good morning, Mr. Chair.
Good morning, sir.
Do you have before you a bundle of documents with two titles? The first at the top of, at least in tram lines, is Index
Yeah.
Statements for 06 April to 10 April 2026. Do you have that?
Yes, I do.
Thank you. And then at page 1649, that's 1649,
Page?
it's 1649, Chairperson, and in the index it's item 1. I think it was extracted
I have it.
from, thank you very much. Are you familiar with that document?
Yes, I am.
Is that your statement that you submitted before the commission?
Indeed.
Have you read the document and confirmed that it is correct and binding on your conscience?
Correctly so.
Thank you very much. May we start then with the introduction, and that sets out your background. Could you briefly go through paragraphs 1 to 7, just setting out your background as a legal practitioner and your involvement in the TRC, and then go into your involvement into the NPA?
I'm at the introduction. I'm an adult male South African, advocate of the High Court of South Africa after having been admitted on the 29th January 1992. I'm a member of the Pretoria Society of Advocates.
Thank you.
Is it 1992 or 1991?
That is the correction I was going to make,
Okay.
Commissioner. The correct year is 1992, not 1991.
Oh, yes. Okay. Thank you.
Thank you, Mr. Chair. You can carry on.
In 1998, I joined the National Prosecuting Authority, NPA, as a Director of Public Prosecutions in the KwaZulu-Natal KZN province. At this time, I was attached to the Truth and Reconciliation Commission, TRC, as Chief Evidence Leader, where I handled TRC amnesty cases and scheduled all amnesty committee hearings. In April 2002, I was transferred to the Office of the Director of Public Prosecutions, DPP, in Pretoria, where I remained until May 2006. In May 2006, I was appointed to the position of Deputy National Director of Public Prosecutions, that is a DNDPP, and I was responsible for the National Prosecution Services, NPS. While I held the position of DNDPP, I served as the Acting National Director of Public Prosecutions, Acting NDPP, from 23rd September 2007 to the 30th November 2009, and I took early retirement from the NPA during or about February 2010. My appointment as an Acting National Director of Public Prosecutions was pursuant to the suspension of Advocate Vusi Pikoli as NDPP on the same date.
Thank you very much. You are aware that you are before this commission in terms of a notice that was issued in terms of Rule 3.3 of the rules of the commission.
Indeed, sir.
And from that notice, what do you understand the reason for you being here to be?
Yeah, I understand the reason for me here is that there are allegations leveled against me that I have conducted myself in the manner in which was, how can I put it, a suppression of TRC cases, and that I am the person who let go of Advocate Akaran from handling the TRC cases. That is my understanding.
Certainly. Thank you very much. So then, in having considered the at least so-called implicating statements made against you, what is your general response two. One, you relieving Mr. Akaran as soon as you started acting, and your role insofar as there was no activity whilst you were the acting NDPP in relation to the TRC cases.
Yeah. My response to the issue of Advocate Ackerman is that the allegation is not correct, or it is untrue, let me put it that way, in the sense that I did not release him of TRC cases immediately, as he says, immediately after my appointment in 2007. That happened later on, I think in 2009, speaking under correction. So it is incorrect that I did that immediately after my appointment.
Yes, Mr. Chair, it means that you are at around paragraph 28. Is that so? The allegation that I relieved Advocate Ackerman of his duties in relation to the TRC, which is at page 1655. Is this where we are?
Commissioner, what I was doing was to telescope what it is that is going to be said. We are still going to refer to the particular paragraphs, but it was just a general response, telescoping where it is we're going, insofar as the implicating statements have been made about Mr. Mshe.
Okay.
And the other allegation that I might have suppressed or stopped the further attention from the TRC cases, and that it was a political action on my part, I say that is also not correct, because that never happened at all. I never suppressed, nor stopped, nor even interfered with the TRC cases.
Thank you, Mr. Mshe. In your statement, you had asked that you want to highlight that you played a role in the TRC itself, and that starts at paragraph 9 of your statement. Could you read that into the record, please?
Thank you. Before joining the TRC, I practiced as a junior counsel in Pretoria. I was then approached by Mr. Tumisan Sebeza, who informed me that the late Archbishop Desmond Tutu wished to meet with me. Mr. Sebeza was at the time the head of TRC investigations, if my memory serves me well, but he was.
Certainly. How did you know Mr. Nzabeza?
I knew Mr. Nzabeza as a result of our interaction during, can I say it, the activism period. I knew him therefrom. We had meetings now and then on the basis of activism. That's how I knew him.
And in what context was he approaching you?
In what context?
Certainly. When he approached you, did you know that the approach was coming? Had you discussed it with him before?
No, not at all, not at all. All what he said to me, because it was telephonic, he just said, we're going to get you to come to Cape Town. It was on a Friday, I remember. The Arch would like to meet with you. And that was it. And then the next thing was that we have arranged the plane for you to fly down to Cape Town the same day on a Friday, I remember.
Certainly. And then you went to Cape Town, and at paragraph 11, you indicate that you commenced serving as on the Amnesty Committee on or about October 97. Did you leave practice, or were you practicing both at the bar and at the...
The arrangement was that my going to the TRC, it was like a brief to me, a brief to the practice. So I did not leave practice.
Certainly. And then you state in the next topic that whilst you're at the TRC, you are appointed as the Director of Public Prosecutions in KZN. Could you give us or elaborate on that, on how it happened, looking specifically at 12, 13, 14?
Thank you. While at the TRC, I was approached by the then Minister of Justice, Dala Omar, and informed that my services were required as the Director of Public Prosecutions for the province of KwaZulu-Natal, KZN.
What was your role?
This is when I was at the TRC, and I did have the meeting with the Minister Dala Omar in his office in Cape Town in Parliament, the meeting started at 2 o'clock. I cannot remember the date. And then when I met with him in his office, then he said to me, people have been talking to me that I must approach you and request you to go and take over the position of DPP in KZN. And I recall my response to him was that, Mr. Minister, I'm still attached to the TRC, and there's still a lot of work to be done. And then he said to me, your two IC can take over. You'll be allowed to go once or twice a month to go and check on the work. And that was the end of our discussion.
Did you accept the position as a DPP in KZN?
I did accept that position as DPP in KZN.
And whilst you were there, what were you responsible for? What was your role?
As a DPP in the province, you are in charge of criminal prosecutions in that province. You are to guide and direct whatever prosecutions are to take place. And you become the head of prosecutions in the province.
And whilst you were there, did you ever come across any TRC matters or TRC related matters?
No, I did not. I did not at all.
Was that because there were none that related to the KZN office of the NPA, or because they were handled by a different office? Do you know why you didn't come across them?
There were a lot of TRC matters that emanated from KZN, a lot of them, because I dealt with them. But we did not attend to them in the provinces because there was a unit that was established at head office, the PCLU, that was dealing strictly with those matters at head office.
Certainly. And then at paragraph 16 of the statement, could you please read that for us?
Yeah. I was then transferred to serve as the DPP in Pretoria from April 2002 until May 2006.
And you go into your role as DNPP. Could you, for the sake of sort of context, expand on that if you wish to?
Okay. On paragraph 17.
17, that's correct.
In May 2006, I was appointed to the position of Deputy National Director of Public Prosecutions, DNDPP. In this position, I was responsible for the National Prosecution Services, NPS, and was based at the head office in Pretoria.
And then 18?
Okay. My role as head of the NPS involved taking charge of prosecutions in the country, managing all the DPPs who reported to me in all provinces. I reported to the NDPP about matters pertaining to prosecutions.
When you say taking charge of prosecutions in the country, did that include TRC cases?
No.
Why
It
not?
does not include TRC cases because, like I said, the TRC cases were handled by PCLU. These are the people who are dealing with that only at head office. And there was a head who was appointed by the president. I think it was President Mbeki then, yes. There was a head who was appointed by proclamation, Advocate Anton Akaran. So in the provinces, we were not dealing with the TRC cases unless when specifically the PCLU would find that the prosecution of this matter should take place in KZN or in Northwest. Then that case would then be dealt with in that province.
Did that ever happen where cases were referred to by the PCLU in matters that involved you?
I remember one that was dealt with in Pretoria. It was dealt with by Anton Ackerman and others that I may not remember, but there are some that were referred to the provinces by PCLU. But the difference was that they would not be dealt with in those provinces by the prosecutors in those provinces. The prosecutor from PCLU would travel to go and do that case there.
So it would be correct then to sum up what you have said as saying that whilst you're DPP in Pretoria, you were not involved at all in TRC matters.
Not at all. Not at all.
And then we will move on to your appointment as the acting NDPP. And we'll start first with paragraph 20, which is at page 1652.
Yeah. I served as a DNDPP until 23rd September 2007, when I was appointed as the acting NDPP. This was upon the suspension of Advocate Vusi Pikoli as NDPP.
And then at paragraph 21.
Oh, okay. During my tenure as acting NDPP, I engaged from time to time with the following persons and structures whose relevance appears later in the statement. 21.1, senior officials within the Justice, Crime Prevention and Security Cabinet Coordination Structures, the JCPS, through which the NPA, SAPS, and the Department of Justice and Constitutional Development ordinarily interfaced on operational matters requiring interdepartmental coordination. Mr. Simelane, who then served as the Director General of the Department of Justice and Constitutional Development from around, I think, June 2005 to September 2009, the Interdepartmental Task Team, the ITT, or the Task Team, which was established to facilitate coordination between SAPS and the NPA in relation to TRC-related investigations and prosecutions. Number 4, the Minister of Justice and Constitutional Development.
Can we go back to your interactions with the Director General, Mr. Simelane? What was the extent of the interaction, and what about?
Mr. Simelane was one of the members in the JCPS cluster. Now, because he was the Director General of Department of Justice, whereas we reported as a NPA, I had quite a number of interactions on matters pertaining to TRC. For example, if there's a prosecution, TRC prosecution, that was taking place, he was entitled to a report thereon for him to forward the same to the Minister of Justice.
But his engagements, were they ever about decisions taken about whether to prosecute or not?
Not at all, not at all. That was the domain of the NDPP.
Certainly. And then you speak about the Interdepartmental Task Team. What was that and when was it established?
I can't remember the date when it was established, but it was a task team consisting of directors general and other members from various departments. The departments that fell within the justice cluster. Discuss matters therein, including the TRC matters.
What
And
was,
the meetings, those meetings were attended only by the national director.
certainly. So what was your involvement as the National Director in issues being discussed by DGs?
The involvement was just to inform them as to where the TRC matters are, and maybe even seek guidance, and maybe even get directives from them as to how to proceed with the matters, which I think my recollection that it never happens when we're given directives.
Certainly. And then at 21.4, what were your interactions with the minister?
Yeah, look, NPA reports to the Minister of Justice, and it was a policy that when a high-profile type of a matter is dealt with, including TRC matters, I want to think of that. The PEPCO 3 matter is an example that comes to my mind. Then the minister is to be informed by way of a memorandum, and the minister would also call for report on any matter within the realm of the TRC. So I had to report to him now and then.
Did the nature of engagement ever extend to decision-making insofar as prosecution is concerned?
Not at all. Even the minister could not do that.
Certainly.
The national director only could.
Thank you. Could you read 22 for us, paragraph 22 at 1653?
When I assumed my role as the acting NDPP, the PCLU, which handled the TRC matters, reported to Dr. Ramayite, who served as the Special Deputy National Director.
Who did Dr. Ramaite report to?
He was reporting directly to the National Director.
And the national director at the time is you acting, is that correct?
Yes, at the time,
Certainly.
yes.
And then in your engagements with the PCLU, did you ever get involved in the manner in which investigations would be conducted or interactions with SAPS would be handled for investigation?
No, I couldn't and I didn't get that involved. But when you mention interaction with SAPS, I can say my involvement was present there for the simple reason that there was a time when the SAPS, and I think NIA as well, were refusing directly into my face that they are not going to investigate TRC matters. Now that is where I got involved and sought advice even from the National Commissioner of Police. I think then it was J.K. Selibi, yes. And I had meetings with him about releasing police to investigate these matters. Same applies to members of NIA.
Certainly. In fact, in the notice, there is a conversation about you trying to resolve SAPS issues with Mr. McAdam, but we will get to that later.
Okay.
If you could then read 23 for us.
Okay. Advocate Akaran was the head of the PCLU, working with Advocate McAdam as the deputy head. Dr. Pretorius was the other member, and they were later joined by Mr. Sean Abrahams. Advocate McAdam was, however, from time to time involved in special projects such as the prosecuting the nuclear case and representing the NPA in the Financial Action Task Force, the FATF. Advocate McAdam returned from the FATF in June 2008 to assume the operational management functions and responsibilities of TRC matters within the PCLU. I detail below the management and operational structure of TRC matters during my tenure.
So when you arrived, the PCLU existed and it was run by Mr. Akaran. Is that the point of the statement?
That is correct.
And they didn't report to you, but reported to Mr. Ramaite.
Indeed.
That's the point. Certainly. And whilst you were there was work being conducted insofar as you understood by this.
Oh yes, work was going on, yes.
Certainly. And then I do not know if you have the notice before you, because it is not included in the bundle, the notice in terms of Rule 3.3.
The 3.3 notice, I think I saw it. Let me check
So
my index.
I'll
Yeah.
give you a moment.
Let me check. I think it's on page 1 to 4. Do you want me to go to it?
Please.
1 to 4.
Specifically, paragraph 270.
No. This is the terms of reference.
Yes, that's what I thought.
Is that the one?
No.
Yeah.
I did not come across
Yeah, it's not
the
there.
notice in
May I just check on this
the
one?
bundle. Certainly. Go
Yeah,
ahead.
there's another bundle here. No,
Okay.
it's not here in this bundle as well.
I suppose for the sake of the record, I will read into the record the parts to which I wish to refer you insofar as the notice is concerned, and then ask the consequent questions, and then we will refer back to your statement insofar as specific and responses and references are to annexures. So at 270, the second paragraph reads, on 23 September 2007, Bikoli was suspended from office by President Mbeki. Shortly after his suspension, he learned that Akaran had been relieved of his duties in relation to the TRC cases. According to Akaran, that's 271, he was summoned to the office of Advocate Mshe, who had been appointed acting NDPP Mche advised Akaran that he was relieved of his duties in relation to the TRC cases with immediate effect. If I may stop there, did this happen?
This did not happen on that date. In other words, Ackerman was not relieved of his duties on TRC matters in 2007.
Certainly. And then it goes on to say, in his affidavit, I'm still at paragraph 271 of the Rule 3.3, it says, in his affidavit, brackets FA8, Ackerman asserted that he had no doubt that Advocate Mche received political instruction to remove me from these cases. Is that statement correct? Were you ever
It is incorrect. I did not receive any political instruction at all.
Certainly. In fact, you will explain
Well,
why.
that was his opinion, I think.
Certainly.
Yeah.
Indeed. Thank you. And then, insofar as that is concerned, may I ask that we go back to the statement, specifically at page 1655, starting at paragraph 2828.
Right. In his affidavit, Advocate Ackerman alleges that shortly after Mr. Piccoli's suspension on 23rd September 2007, I immediately assumed the position of acting NDPP, and I summoned him to my office and advised him that he was relieved of his duties in relation to TRC cases with immediate effect. This is incorrect. While I confirm that I relieved Advocate Ackerman of his operational functions and responsibilities in relation to TRC matters, this did not happen immediately after my appointment and the suspension of Advocate Piccoli. I also explained below the reason and context within which I relieved Mr. Ackerman of his operational functions and responsibilities in relation to TRC matters.
29.
Soon after my appointment as NDPP, I held briefings with various stakeholders, including those that were responsible for TRC matters as mentioned in paragraph 21 above. During these engagements, it had become apparent to me that there was much acrimony directed towards Advocate Ackerman and his management of TRC matters. In my opinion, these were personality issues.
Carry on.
Further, during or about November 2007, I received information concerning a complaint lodged by Reverend Frank Chikane, who was the Director General of the Presidency. Reverend Chikane had been a complainant in the matter of State versus Van der Merwe and others. This matter concerned the poisoning and attempted murder by security police of Reverend Chikane by the accused. Mr. Ackerman was the prosecutor in this matter. I attach here to marked annexure MJM1.
May I ask that we go to MJM1 because I'd like to draw your attention to specific paragraphs.
Yes. I don't know whether...
It is at page 1663, so 1663.
Thank you.
It's MJM1, annexure.
My pages don't have 16. The act finishes at 315. Let me check on this one.
Certainly.
Because there are two bundles here.
Certainly. 1663.
No. This one ends up with 1113.
Okay. So could you just go to the end of the statement
My
that you have? Yes. Where you found it. Maybe the annexures. It's just better to refer to the annexures instead of page numbers. May I ask that you go to the last page
The last page of my statement.
of your statement? If you can find that.
Yeah,
you have that?
in last page I see Alexa MJ M1.
Over the page, that's correct.
Yeah.
Okay. You have already referred to the letter, but I want to specifically ask that you read the third paragraph of the letter.
The one that
Given the
starts with-
context that this is the letter that Mr.
Yeah.
Chikane or Reverend Chikane sent to the minister complaining about the prosecution of his case.
That
So I
will be the paragraph starting with the first point.
the first point, that's correct.
The first point I would like to raise is the handling of this matter by the National Prosecuting Authority, NPA. From my interaction with the relevant officials within the NPA, it is clear to me that the said officials are simply the wrong people to deal with the matter. In fact, they did not seem to understand the nature of the challenge we were facing. Firstly, my court case was used to fight battles between the NPA and the government about the guidelines for dealing with post-TRC cases. Throughout this process, I was left with a feeling that no one, in fact, cared about me as a victim. What mattered were the politics around the handling of the post-TRC cases and how people would win their battles.
Let's start with the NPA officials to which the letter refers. Who did you understand them to include? Did it include Mr. Akaran?
Yeah, it would mean Mr. Ackerman.
In fact, he's named by name in the next paragraph, which I'd ask that you read as well.
As part of the consultative processes relating to the case of the State versus Van der Merwe and others, Advocate Ackerman, the Special Director in the Priority Crime Litigation Unit, and his assistant visited me as the victim, in brackets. Instead of just consulting me as the victim, he entered into an acrimonious argument with me about the approach of the government on post-TRC matters and the guidelines. From this interaction, it was clear that he was radically opposed to the guidelines as agreed upon by Cabinet and the Parliament of the Republic of South Africa. In fact, he seemed to be more interested in prosecution for the sake of it, rather than the management of this difficult post-TRC process.
Is this one of the issues that you say you considered from stakeholders that affected or reflected badly on Mr. Ackerman and his interactions with stakeholders?
Yes, this is one of them, yes.
Thank you. Could you then read the following paragraph, and that's
Okay.
the last paragraph I'll ask you
Okay.
to read of this.
What I detested most was that my case was being used to fight their battles with the government. In pursuit of this objective, a draft letter which was constructed in a manner that would enhance their position in the prescribed forum with other departments was presented to me for my signature. What was more disgusting for me was that when I refused to sign the draft letter, Advocate Ackerman then threatened to use Section 204 of the Criminal Procedure Act against me to force me to surrender all the information he claimed I had received from Mr. Vic on my poisoning. I dared him to do so.
Mr. Flock,
Oh, Mr. Flock, thank you. Thank you, Commissioner. I dared him to do so and reminded him that this was tried against me during the apartheid days and it did not work, and that there is no reason why it would work now. He backed off and left. His colleague who was with him is my weakness in this regard.
Who is the colleague that was with him? On the understanding?
Advocate Tunzimaga.
Thank you. And then, whilst in sort of considering this letter, I asked that you go to MJM2.
I think it should be part of this. It will be down the line.
It is just a couple of pages,
down the line.
certainly. So if you look at Mr. Chikane's signature,
MJM,
2,
okay, I see MJM3B. Let me go back.
That would be at page 1666.
yes.
1666, thank you. Thank you, Commissioner.
It's a letter or a memorandum of 24 January 2008.
Yes, I am there.
Thank you very much.
It's a letter to the minister.
Yes.
Yeah.
And I won't ask you to go there because it's long. It's a letter that is under your signature at 1672. Do you confirm that that's your signature?
Just to confirm first. Yes, indeed.
All right. So then, if we may start with the introductory paragraph, which reads, as requested.
Yeah.
Who had made the request that resulted in this letter?
The minister.
How was the request made?
The request was made in writing to comment, or asking the NPA to comment on the complaint by Reverend Chikane.
So that's how you came across.
Sorry, before you go too far, the letter is dated the 24th of January 2008. Is that correct?
That is correct, Commissioner.
Yes, sorry to interrupt, but you can continue.
Yeah.
Thank you, Commissioner. So is that how you came across or came to know of Mr. Chikane's complaint?
Indeed.
Certainly. Could you then just explain to us what the nature and spirit of the representations were before I refer to the particular paragraphs? Did you write this on behalf of the NPA or you as the NDPP, or did you write it on behalf of the officials about whom the complaints were made?
No, I wrote this on behalf of the NPA as the head of the NPA responded to the minister.
Thank you. Could you, at page 1667, 1667, read paragraph 2?
As a result of this letter and the prominent role played by Advocate Akaran, I have deemed it prudent to relieve him from all TRC-related duties since November 2007.
And can we confirm that November 2007 is after the letter from Mr. Chikane?
Indeed, indeed.
Certainly. And then, insofar as how you proceeded going forward, could you please read paragraph 4 on the same page?
Yeah. I have decided that all future post-TRC investigations and prosecutions be managed by Dr. Ramaite, Advocate Maga, and the TRC task team.
So it would be incorrect for anyone to assume, speculate, or indeed contend, as a matter of fact, that after relieving Mr. Akaran of his responsibilities, there was no assignment to other people of the cases.
No, that would be incorrect because there were people who were manning that unit.
And you understood or believed those people to be competent to prosecute the case?
Indeed, indeed.
Could you go under add paragraph 4 for us, please?
At paragraph 4, both advocates Ackerman and Maga denied that there was an acrimonious argument. See also paragraph 5 infra. Advocate Ackerman admits that he had some concerns about the guidelines and in a number of official memoranda raised his concerns on the constitutionality thereof. Despite reservations, he diligently applied the criteria as stipulated in the guidelines. With the wisdom of hindsight, it appears that there was some merit in Advocate Ackerman's reservations. Indicative thereof is the institution of a civil action in the High Court challenging the validity of the TRC guidelines. It is the Nkadibeng and others versus NDPP and Minister of Justice and Constitutional Development.
Thank you. So would it be fair or reasonable to say that in this, or before you wrote this, you engaged Mr. Akaran about the complaints?
Indeed, both Ackerman and Maga.
And you allowed him an opportunity to state or at least respond to what was said about him?
Indeed.
Thank you.
And would it be correct for me to conclude that you supported them in this letter to the minister?
Yes, I did.
Thank you. And then if we may go to add or response to paragraph 6, which is at 1669, and it's under the heading add para 6.
Paragraph 6.
Add paragraph 6.
Yeah. Advocate Ackerman admits not having consulted with Reverend Chikane on the details of the plea and sentence agreement. Advocate Chikane, they said Advocate Chikane, all right, was, however, informed of the proposed suspended sentences.
Certainly. So in his engagement with you, Mr. Akaran confirmed one of the complaints that Mr. Chikane raised.
Yes, that of not having explained to him in full the meaning of the plea sentencing.
What did you think of the failure to engage Mr. Chikane about this?
I think that was out of line by Advocate Ackerman because you need to take on board with you the victim. He's got to understand everything about the plea agreement and he's got to consent thereto. I think it's just a little bit out of line by him.
Certainly.
But he did at the end inform him about the sentence that was proposed in the agreement. Yeah.
Indeed. Thank you very much. If we then could go back to paragraph 30 of your statement, that is where the conclusion, insofar as those documents are concerned, it's at 1656. And in fact, it confirms what was put to you by the Commissioner about supporting Mr. Ackerman in your response. But could you please read paragraph 30 for us?
I fully supported Mr. Ackerman in his response to the complaint, as is fully set out in my letter to Minister Mabandla, but the perception of him by stakeholders and the acrimony directed against him remained. And this would, in my considered view, compromise the necessary cooperation between the PCLU and the stakeholders with whom he was required to interface in his work relating to TRC matters. Accordingly, and with effect from November 2007, I deemed it prudent to relieve Mr. Ackerman from TRC-related duties. I think there's a mistake there. TRC-related duties and responsibilities. I was, however, confident that this could be done without compromising the work on TRC matters, as Advocate Chris McAdam would take over the TRC operational management and responsibilities as soon as he finished his FATF project. I attach here to my letter dated 24 January 2008, marked as Annexa MJM2, directed to Minister Mabandla, wherein I confirmed Mr. Ackerman's removal and addressed the complaint against Mr. Ackerman by Reverend Frank Chikane.
Thank you. Before you removed Mr. Ackerman, did you ever engage anyone else, including members of the PCLU?
No.
Did you engage Mr. Ramaite, who you said was the head of the PCLU?
Yes, I did engage. I tried to engage with both of them, Mr. Ramaite as well as Anton Ackerman.
So an assumption or speculation that you took this decision based on political interference would not be correct.
That would be incorrect.
An assumption that you did this without thinking about it and without engaging Mr. Ackerman would also not be correct. Is that
Very
correct?
incorrect.
Thank you.
Before you move on, are you moving on to
I am.
something else?
I am.
Okay. So can I ask
Certainly.
just two questions here? Advocate Mshe, in paragraph 29 and in paragraph 30, you deal with the reasons for the discord between Advocate Ackerman and members of the groups. First, you say that it's appeared to you that these were personality issues. And then you refer to the perception of him by the stakeholders in very acrimonious terms. Are you able to explain a bit more about that?
Yeah, on personality issue, I was actually referring to Ackerman himself. He was the type of a person who just blab and say things that were not supposed to be said. He was that type of a person. But he was just a jolly person who just talk. And that's why I say it was personality issue. On the question of acrimonious attitude towards him, I was referring here again specifically to the complaint by Reverend Chikane, as well as insinuations and remarks that one would hear in meetings about him heading the PCLU. There was that feeling that he should have long been removed. He's not the right person to head the PCLU. And that was not in keeping with him doing the work, according to them. Yeah, that's what I was referring to.
Okay. Thank you.
Thank you. We're going to move on now to whether or not Mr. Ackerman remained involved, because that's also an insinuation in the Rule 313 in the matters. It is as if you completely sidelined him, I beg your pardon. Could you read for us paragraph 31?
Yeah. I refer to an internal memorandum dated 5 June 2008, addressed by Advocate Ackerman to Dr. Maite, the then Deputy National Director of Public Prosecutions, the subject matter of which is the TRC task team. In that memorandum, Advocate Ackerman refers to a meeting between him, Advocate McAdam, and Dr. Maite, which concerned new internal arrangements and allocation of functions and responsibilities for TRC matters, and confirms the following. 1, that Advocate McAdam, who had now returned from FATF, will supervise and manage Advocate Maga. 2, that Advocate McAdam will attend all meetings of the task team, and attention will be paid to all investigations registered to date. And in that regard, Dr. Bukau will also be co-opted to deal with certain matters.
May you just stop there, please? What matters are you referring to? Are these the TRC matters or general?
These are TRC matters.
Thank you.
Yeah.
You can go on to number 3.
Thank you. That prosecutors will not perform functions that will usurp the duties of the SAPS and NIA. That the PCLU, as contemplated by the guidelines, will be responsible for operational management of TRC matters under the supervision of Dr. Maite and that of the NDPP. The memorandum deals with TRC matters, such as the PEPCO 3 case. I attach a copy of the internal memorandum marked MJM3A, MJM3B, MJM3C, MJM3D. It is noted that these internal arrangements concerning TRC matters were being implemented under the overall supervision of Mr. Ackerman.
So he had overall supervision despite you having relieved him of his duties. What do you say about that?
Well, the allegations that I removed him in 2007,
Yes.
and I did not do that in 2007. I did that in 2008 as per letter to the minister. But what I've just read here indicates that the allegation of 2007 is incorrect, because it is clear that way down in 2008, he was still dealing with TRC matters. Am I responded correctly?
You have. It's just there's an issue I wish to get clarity on. You've now twice said you removed him or relieved him of his duties in 2008. However, in MJM2, if you could go there, that's the letter of 24 January 2008.
Yeah.
And if you go specifically to paragraph 2,
Yeah.
you say, I'll wait for you to get there. Or
Is
you
it
say
where-
as a result
is it
of,
where I mentioned 2007?
certainly.
Yeah. You will recall when I read that, I said there is a mistake here. Yeah.
So you stand by that you only relieved him in 2008 despite what is said here?
Indeed.
This is an error in
Yeah.
this letter.
It's an error, the 2007.
All right, thank you.
Yeah.
Could you then go to paragraph 32?
Yes.
Sorry, can I just ask a clarification question? What did you mean in this letter when you say you relieved him of all TRC-related duties?
That is the management thereof and the prosecution thereof. He was off, but he still remained the head of the PCLU.
In a supervisory capacity?
Indeed, he still remained there.
Thank you.
And in fact, that is what you state at bullet point 4, that it is noted that these internal arrangements concerning TRC matters were being implemented under the overall supervision of Mr. Akaran.
Yes.
That's in line with what the Commission
That is
was.
correct.
Certainly. Could you please read 32 for us?
I refer to an internal memorandum dated 9 June 2008, addressed to me by Advocate McAdam, relating to TRC cases wherein he discusses the NPA annual plan that required the PCLU to formulate an action plan for the prompt and effective disposal of TRC cases. Advocate McAdam in the internal memorandum that as a consequence of the action plan decision, Advocate Ackerman and him had meetings with Advocate Mzinyati and Dr. Ramaite, pursuant to which an agreement was reached that Advocate McAdam should attend the task team meetings as well as any strategic discussions involving Dr. Ramaite and I. I attach a copy of the memo marked Annexure MJM3E.
We will refer to the memo and its contents later. Could you just go on to 33?
Okay. The next email is dated 9 July 2008. It is from Ms. Helena Swart, who was an assistant in the office of Advocate Ackerman and Advocate McAdam. Its subject matter is also TRC matters and is addressed to Advocate Ackerman. The email lists several TRC matters which Advocate McAdam requests Advocate Ackerman to address during his absence the following week. I attach the email marked as Annexure MJM4.
34?
The next memorandum is dated 1st October 2008 from Advocate McAdam, addressed to Dr. Ramaite and copied to Advocate Ackerman, and deals with the TRC cases of Dr. Anton Luboski. I attach the email as Annexure MJM5.
So it's a year later and Mr. Ackerman is still engaged.
He is still there and he is still engaged in the TRC matters.
By a year later, for the record, I mean a year after your appointment.
A year after, yes, yes.
Paragraph 35.
On 10th December 2008, Advocate McAdam addressed an email to Dr. Ramaite in which Advocate Ackerman is copied again. And the email reports on TRC issues of the year 2008 and notes that the majority of matters referred to therein can only be taken forward with the assistance of SAPS and NEA. It further recommends that, as a matter of urgency, in 2009, a meeting should be set up with the acting NDPP, Advocate Ackerman, and Advocate McAdam to obtain the NDPP's approval on the way forward. I attach a copy of the email marked MJM6.
And then your conclusion at 36.
The memorandum referred to above are a contemporaneous record and reflect that Advocate Ackerman was months after my appointment as acting National Director of Prosecutions, allocating operational management functions and responsibilities related to TRC matters. This after consultation with Dr. Ramaite, who was the DNPP responsible for PCLU and TRC matters. Mr. Akaran therefore retained his supervisory role over the staff dealing with TRC matters within the PCLU. I had no objections to this arrangement.
Thank you. So then, to go back to the Rule 3.3 notice, which I accept you do not have, specifically paragraph 271, and in concluding on what you have read to us, it would be incorrect that you removed Mr. Akaran as a result of or after receiving political instruction to remove him from the case.
Completely incorrect.
And he also, at least in the notice, it is stated that Akaran advised him, that removing him from the TRC cases would not make the cases go away. Is that correct?
I don't remember hearing that from him.
Thank you. We will then move on to paragraph 305.
Mr. Salugasana, if I may just interpose, we've gone past our tea adjournment time. Would this be an appropriate time to adjourn for tea before you go to the next issue?
It would, Chairperson. Thank you very much.
We'll adjourn until 11:30. Thank you, Mr. Salugazana.
Thank you, Chairperson. We're going to go now to the other allegation or implication at paragraph 305 of the Rule 3.3, and because you do not have it, I'll read it. It can be safely assumed that little or no work was carried out by the NPA, SAPS, or TSO on the TRC cases during 2008. Acting NDPP Mshe had already relieved Akaran of his responsibilities in respect of the TRC cases. He could hardly be expected to champion the TRC cases going forward, and indeed did not. Let's start with the last statement, that he could not be expected to champion the cases, and he did not. This statement is not correct, am I correct, if you take into account that he was still involved in 2008 October?
Yes, it is not correct.
And then, insofar as the first sentence is concerned, that there was little to no work carried out on the TRC cases during 2008, that too is not correct, am I correct?
Not correct at all.
And in fact, in the annexures, there are updates that you give to the minister about what was going on insofar as the cases are concerned. And I'm going to ask that we refer to two annexures that demonstrate that. And the first is MJM7 to your statement, and it is at page 1691. It is a memorandum from you to Minister Surti, dated 17 February 2009.
Yes, I have it.
What is this document? Do you recognize it?
Yes, I did. I do recognize this memorandum, which was directed to Minister Surti.
Were you the author of the memorandum?
Yes, I was.
So could you read what the purpose of the memorandum was at
And
paragraph 1?
And it is dated the 17th of February 2009, is it?
That is correct, Commissioner.
Yes.
The purpose of this memorandum is to inform the Minister of my intention to reconvene the TRC task team and to advise him of matters relating thereto.
Why did you have to reconvene the task team? What had happened to it?
The task team had gone into some kind of a lull regarding the investigation of TRC matters. Nothing was actually going on in that unit or in that structure. And my reconvening thereof was specifically targeted at getting them to assist in the investigations.
Thank you. I will then go down to the briefing paragraph, which is at 3.1 at page 1692.
Yeah.
Could you read that for us, please?
Members of my office have met with the Divisional Commissioner of the Detective Service of SAPS and the Deputy Director General, Operational Support of NIA. Both agencies have indicated their willingness to again participate in the task team and to perform duties within their agency's mandates.
Could you give us context on what you meant there?
This is as a result of my communicating with them, with the task team members who are outside, that is SAPS and NIA and others, and requested them to give assistance to the investigations. They then agreed that they will come back and perform the duties. The duties basically is investigations. That is what is meant in that paragraph.
Thank you. Paragraph 3.2.
After I have received feedback from you, I intend submitting written invitations to the relevant directors general, inviting them to nominate staff members to form part of the task team and to arrange a date for the first meeting of the task team.
3.3.
No requests to investigate TRC matters have been received since November 2007. And it is anticipated that once the matters on hand have been dealt with, that the chapter on these cases may be closed. In its report released in 1998, the TRC did in fact recommend that a time limit should be imposed on such prosecutions.
Thank you. And then the following paragraphs, you list the cases,
cases,
that
yes.
were ongoing.
Yeah.
Were these cases that were, or at least your office was still, the PCLU was still working on
Indeed.
throughout your term?
Yes.
So
yes.
this report is an indication that there was work going on and that you were giving a status report on the work that was being done.
Indeed.
So a statement that little to no work was done when you've given a report on at least 9 cases is
Incorrect.
unfair and incorrect. Thank
Can
you.
I take you back to paragraph 2.2?
2.2.
You say, since 2007, the task team has not sat due to the fact that matters relating to it were tabled before
The Kinuala Commission.
Shinwala Commission. The effect thereof was that investigations into TRC matters could not continue.
Yeah.
So you're saying from November 2007 to when you wrote this letter, February 2009, there were no investigations.
There were no investigations.
Okay.
Yeah. And as that paragraph indicates, 2.2, the main reason why very little was done or nothing was done was because of the sitting of the Kinuala Commission that was where Advocate Piccoli was appearing.
And the TRC matter figured in there somewhere.
Yes, they did.
Okay.
They did.
All right.
Thank you, Commissioner.
Thank you.
Thank you. I will then go back to your statement. Again, we're dealing with the allocation or the TRC portfolio and role of allocation. If you
Is
could
it still on page 16?
No, we're going back
To the statement.
page 1659 of the
Yes.
statement,
Yeah.
paragraph 37.
Yeah.
If you could read that for us, please.
I deny that I stopped or intended to stop the investigation or prosecution of TRC matters, whether by instructions, policy formulation, or any stratagem, or that I acted on any improper political instruction, or that I participated in any collusion to suppress the investigation and prosecution of TRC matters.
38.
I have already explained that I did not engage in any matters relating to the TRC which were being considered by the PCLU.
What did you mean you did not engage in any matters?
Engage here would mean I did not participate, say, when they sit, when the PCLU sit, and they consider a particular application, it would be their duty alone, maybe under supervision of, or with the presence of Dr. Ramaite. But I would not be sitting in their work processes.
Okay. If you go to 39, please.
Thank you. While I was acting NDPP, sorry, I had no reason to believe that there was any interference with prosecutorial discretion. This is supported by reports that were tabled at meetings I attended with the leaders of various units, including the PCLU. To the extent that there were delays, inactivity, or limited progress in any matter during my tenure as the acting NDPP, those circumstances must be understood against the practical constraints that existed at the time. The prosecution of complex historical matters is ordinarily dependent on complete investigation dockets, the identification and location of witnesses, sufficient admissible evidence, and the ability of the investigative authorities to prioritize and execute the required investigative steps. Challenges in interdepartmental cooperation and coordination may therefore have affected capacity and timing. Those constraints do not, without more, amount to interference with prosecutorial discretion, There were, however, constraints regarding the availability of investigators because the SAPS management and the NPA differed in the interpretation of each other's roles in the implementation of the NPA policy and guidelines.
And in the light of this, to take you back in giving context to the question from the Commissioner about there not being any investigators, did that have an effect on insofar as the prosecution of the TRC cases were concerned after the dissolution of the task team?
What is it that you said?
I'm asking, the Commissioner asked you or referred you to a paragraph of your letter
Yeah.
of February 2009,
Yeah.
paragraph 2.2, that says that as a result of there not being a task team,
Yeah.
there have been no investigations or investigators available.
Yeah.
Here you talk about those constraints.
Yes.
Would I be correct then in saying that amongst those constraints was that there was no task team to investigate?
Yes.
And
Yes,
amongst those constraints was also that there was an issue between SAPS and the NPA and the NIA about investigations.
Indeed. Indeed.
And without the investigations, the NPA could not really conduct its work.
It could not do anything because these TRC matters. First, when they appeared in the TRC, there were investigations. Remember, I'm sorry, the TRC had specialized investigators who came from abroad. I think USA sent us some investigators, and I think Germany also sent us some investigators. So what they were doing, they will do investigation in accordance with their mandate. But thereafter, then you needed SAPS or NIA to continue with investigations to complete a docket to put together the evidence for prosecution purposes.
And without that involvement of investigations, or
Nothing could be
conducting
done.
of, certainly.
Nothing could be done.
And what was the issue, as you understand it, between NPA and SAPS?
Oh, it was a tough issue, Commissioner.
Explain, please.
Yeah, it was a tough issue in that what I recall is that the Scorpions, the DSO members, were trained by Scotland Yard. They were trained abroad and not in South Africa like the SAPS members. And that was not taken well by SAPS. And that they made it clear to us. Number two, it was the issue of the salary that the DSO, the Scorpions, was giving to its members. That affected SAPS in that the senior members of SAPS resigned from SAPS to join the DSO. So that created that tough issue.
But you say here that they differed over each other's roles in the implementation of the NPA policy and guidelines. What was the difference there? Is that what you've just described?
Is what I've just described, as well as, because that implementation, as well as the involvement of Section 105A of the Criminal Procedure Act. They said that should not have been done, or that we should not do as the NPA, because these matters are political matters, and people need to be seen to be prosecuted, and not been given I remember one member said to me, a free hand after committing a crime.
Thank you.
Yeah. Thank you, Commissioner.
Thank you. In line with what you have said, I'm going to at least refer you to the Rule 3.3 notice, specifically paragraph 306, and we'll ask for your comment insofar as that is concerned. And it is, McAdam records in his affidavit filed in Rodrigues, that in early 2009, Mshea summoned him to his office and showed him a letter written by SAPS indicating that it was withdrawing from the ITT. The ITT is the task team.
Yes, yes,
And-
that is correct. Yeah.
So even they, or at least insofar as the Kalata statement is concerned, and the Rule 3.1 or 3.3 acknowledged that there was a withdrawal by SAPS from investigations.
Yes, yes.
And then at 6.3, the Galata affidavit states, Mshe asked McAdam to negotiate with SAPS and try to get them to agree to investigate cases. Mshe also told McAdam to take over the TRC cases.
Yes.
This is in 2009, is that what happened?
That is correct.
Thank you. I ask that we go back to your statement at paragraph 40, page 1661.
Thank you.
If you could read paragraph 41 for us, please.
I do not accept that the position can properly be reduced to a simple assertion that no work, in quotation, was done or that matters were left unattended, in quotation. The available contemporaneous documentary record reflects internal management and supervision arrangements concerning TRC matters within the PCLU during 2008, including the arrangements recorded in MJM3 annexed here above.
So despite the withdrawal during or at least after 2007, there was still activity within the NPA insofar as those cases are concerned.
Yes, yes.
So it's not that there was no work done in the light of the withdrawal.
Not at all.
So then, at 306.2, I beg pardon for the jumping around, but of the Rule 3.3, it says,
Okay.
since the SAPS had not been investigating the TRC cases, their withdrawal did not mean much. However, according to McAdam, it would mean that going forward, the TRC matters would again not be investigated because the decision had already been taken to disband the DSO. To start with the first sentence, since the SAPS had not been investigating the TRC cases, their withdrawal did not mean much. Is it correct that you were not frustrated or impeded or crippled by the withdrawal of investigators?
I wouldn't say we were not frustrated. We were frustrated, but the frustration was manageable in the sense that NIA was still there to assist, though they also were assisting on a, can I say, a limited scale, but work could still be done despite SAPS withdrawal.
But would it be correct to say that SAPS's withdrawal was not insignificant?
No, it was not insignificant, indeed.
Certainly. Thank you. I'm going to jump back to your statement.
Yes.
And again, in the same line of concerning the investigations, if you could read paragraph 42.
Yeah. I further record that any material progress in TRC prosecutions depended on investigative cooperation, docket readiness, and resourcing, all of which were not within the unilateral control of the NPA.
Carry on, please.
Okay. To the extent that it is contended that any alleged inactivity in 2008 is itself proof of intentional suppression or collusion, I deny that inference.
44.
I dispute that it is factually correct or that it can be assumed that little or no work was carried out by the NPA, SAPS, or DSO on the TRC cases during 2008. I have referred above to internal memoranda from MJM3 to MJM7 as examples showing that work was being done during 2008 regarding TRC matters. These are merely examples and are not exhaustive. In addition to that, I attach my report to the then Minister of Justice and Constitutional Development of the TRC work that was done during the relevant period, marked as Annexure MJM7. I also attach here to a memorandum marked MJM8, dated 28 May 2009, addressed to Minister Jeff Khatebe, in which I report on the PEPCO 3 matter. The last page of the memorandum is, however, missing and will be finished as soon as I find it.
Thank you. We've dealt with the inactivity. Do you wish to add anything to the allegation or implication that there was inactivity during 2008, which was within your acting stint?
I don't think there's anything I can add further. It's safe to say that that statement is incorrect.
Thank you.
Were any prosecutions brought during your tenure?
Yes, Commissioner. Yes.
Can you recall approximately how many?
Whoa. I can't,
That's all right
I
if you
can't
can't
recall.
recall.
I can't recall. I'm sorry. Thank you.
In addressing the Commissioner's question, may I refer you to MJM7 at page 1691. It's a memorandum from you to the
Minister. That is the one dated 17 February 2009.
Certainly.
Yeah. Do you want me to read that as well?
No, I ask that we refer to paragraph 3.4, and the case is listed under that.
Oh, yes, yeah. The following matters are on hand at present. These are matters, when I say on hand at present, these are matters that the PCLU was busy with in terms of collating evidence, in terms of ensuring that there is a proper docket with prima facie evidence to can go to court. These are the cases that I have listed here under.
Okay. All right. That was just to refer to the cases.
Oh, sure.
Finally, if I may refer to paragraph, at least what is paragraph 315, under the implications section of the Rule 3.3. And it says...
Please, can I interrupt you?
Certainly.
Because I know you've moved on to something else.
Yes. Yeah, go
It's
ahead.
that existing letter, MJM7, page 1694,
Yeah.
paragraph 4. Can you just read that?
All of the above matters, except for the PEPCO 3 case, required investigations by SAPS before I can make a decision whether there are sufficient grounds to institute prosecutions or not.
Okay.
Yeah.
So it seems that they weren't prosecution ready.
They were not as yet. That's why when my lawyer asked me, I said these are cases that they were busy with,
Busy with.
collating admissible evidence, getting a docket ready for prosecution purposes. But PEPCO 3 was already in the
this
pipeline.
dovetailed with the period where SAPS was not cooperating.
Indeed.
Okay, thank you.
Thank you, Commissioner. Back to the Rule 3.3 notice, specifically the quoted paragraph 315, which says, on 1 December 2009, President Jacob Zuma appointed Advocate Menzi Simelane as NTPP. This was announced in a government press release dated 30 November 2009, ironically titled, Simelane Fit to Hold Office. The appointment was made notwithstanding the damning findings made against him by the Chinwala inquiry. And then paragraph 316 says, while he was DOJ Director General, Simelane had pressed Pikoli to remove Akaran from the TRC cases. I can only speculate, but I believe that the probabilities are high that it was also Simelane who asked acting NTPP Mshe to remove Akaran from the TRC cases following the suspension of Pikoli. The arrival of Advocate Simelane at the helm of the NPA was to doom the TRC cases to further neglect. I want to direct you to the statement, one that starts with, I can only speculate. Is the speculation reasonable that the probabilities are high that Mr. Simelane asked you to remove Mr. Akaran?
The speculation, as he states, for me recalling, is not improbable. And I will substantiate that. It is because that happened to me as well in passing. It was not in a meeting, it was not written anywhere. But I recall I was with Advocate Simelane, who just remarked to me and said, "Hey, Chief, why are you keeping Akaran there?" So that's why I say that speculation may be closer to what happened.
Certainly.
Yeah.
And then we will turn back to your statement, the concluding remarks you make there.
Yeah. Must I read?
Yes, please.
Yeah. Conclusion. For the reasons set out above, I deny that I did anything to stop, suppress, or improperly interfere with TRC-related investigations or prosecutions. I have responded to the allegations in the Rule 3.3 notice as fully as I am presently able to do so on my personal knowledge and on the documents presently available to me. From my knowledge and involvement in the TRC matters, I deny that there was any political suppression or interference with prosecuting any TRC-related matters.
Do you wish to say anything in addition to that?
No. Unless
Thank you.
directed by the commissioners, I can comment on whatever they want me to comment on.
Thank you very
But
much.
I think I stand by this.
Thank you. Chairperson, that's Mr. Mshe's evidence in chief.
Thank you, Mr. Salukazana. Ms. Pillay, are you going to put questions of clarification to Advocate Mshe?
Thank you, Chair. We won't be putting questions of clarification, but we do reserve the right to bring an application to cross-examine, which we will be doing so shortly.
Thank you. Ms. Ranto? Thank you, Commissioners. Just a few questions for clarity. Commissioners, I'm not aware if, well, I just want to confirm if the Secretariat did make available the supplementary affidavit of General Jacobs to the Commission. Yes, we have. And also perhaps to Advocate Mshe.
I do have.
Good afternoon, sir.
Good afternoon.
There is an affidavit of General Jacobs, I think that was put before you, and specifically there is a letter attached to it, that's SA1 to that affidavit. In essence, it's a letter from the acting National Commissioner at the time, Commissioner Tim Williams, addressed to you. So I would like to confirm if this letter was indeed received by your office. If you have a recollection of this letter from the SAPS.
This very letter.
It's attached to that affidavit. It's
There's a
attached
letter.
as SA1, please. It's dated 7th March 2008.
To Advocate Mshe, Acting Director. Is that the one?
Yes.
Yes.
That's the one.
SSA1, yes.
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 You remember?
If it was referred to me, then it means it was received by my office.
Okay.
Yeah.
And again, without really delving deeper into the contents of the letter, the first paragraph refers to the ITT meeting that was scheduled for the 13th of March 2008. You see that just under the,
Yes,
the subject.
I see that.
I just want to clarify if that would have, or that accords with what you just testified on earlier regarding the invitation that you sent to the SAPS regarding the ITT meeting that was supposed to be scheduled.
Yeah.
That talks to that.
I see the contents thereof, but it does not trigger my mind.
Yeah, just speak up, I can't hear.
Oh, sorry. I've just read the contents of the letter, but it does not trigger my mind as to what is said here, but save that I did indicate somewhere in my affidavit that I had wanted the task team to be put back. Yeah, as he says in his letter. Yeah, that is correct.
Thank you, Advocate Chair. And then there was a question by Commissioner Gabriel about the TEF between the SAPS and the Scorpions. And you remember?
Yes, I do remember.
You recall that you informed the commissioners that there was an issue about the Scorpions having been trained in Scotland and the packages being better than those of SAPS.
Yeah.
And that, as you said, may have contributed to sort of a conflict
Yes.
between the two institutions.
Yes.
But again, I would like to also clarify in relation to the memorandum that is annexed to your affidavit as MJM7. I think specifically there's a paragraph 3.1 to that memo. That's the memorandum dated 3rd of March 2009. That is annexed to your affidavit.
Do you want me to go to it?
Perhaps for convenience, if you may.
Yeah. What page is that?
It would be annexure MJM7 to your statement.
1691.
Thank
All
you.
pages. Thank you.
Thank you.
Deputy
Thank you,
Commissioner.
Commissioner. 1691, yes. MJM7.
Correctly, so yes.
Yes. Yeah.
Paragraph 3.1 of that memo.
Must I read it?
No.
Oh.
I just want to
Yeah.
just refer you to that where you talk of, and that's the memo that you confirmed to the commissioners that it was signed by you,
Yes.
addressed to the minister.
Yeah.
And what is indicated is that both agencies, which now it referred to SAPS and NIA,
Yeah.
that both agencies indicated their willingness to again participate in the task team.
Just him.
In the context of what you indicated to commissioners about the TEF that was going on between the SAPS and,
Yes.
and the Scorpions at the time. I want to understand that your evidence is that notwithstanding whatever conflict that may have prevailed at the time between the two institutions, there was nonetheless willingness on the part of SAPS and NIA to assist.
Indeed, that's correct.
And then also there was an issue, that's actually, I think it's, if I'm not mistaken, it's MJM capital A, but nonetheless, you don't have to go there. That's a memo by Advocate Akaran. I think the one that indicated that SAPS, in fact, NPA would not accept the functions that were reserved for, I think it was
SAPS
PCLU,
and
SAPS
NIA.
and
SAPS-
NIA.
SAPS and NIA,
Indeed, so
yes.
thank you for that.
Yeah.
And that, in light of also what you indicated in paragraph, I think paragraph of your statement, but I think it's paragraph 39. You spoke of challenges in interdepartmental cooperation and coordination that
Yes.
existed at the time.
Yes.
And to your knowledge, was there any document that related to regulating the relationship between the SAPS and NPA, perhaps and NIA as well, insofar as the implementation of these tasks, the tasks assigned to ITT consent that existed, maybe?
I don't remember existence of any such document, except that what was between, or amongst these institutions was for them to conduct their work in accordance with their mandates. For example, the paragraph you quoted right at the bottom, I don't know the page, where I say prosecutors should not be seen to be usurping the powers of SAPS and NIA. We're simply saying the prosecutors should not see themselves as NIA or SAPS and do the work that was supposed to be done by SAPS and NIA. That is what I meant.
Okay. Would I be correct that in a way, the manner in which the prosecution/investigation of TRC cases was concerned was done almost in a manner that's not coordinated, so to speak? It was not coordinated, it was not regulated. In other words,
No, it was not
coordinated.
regulated. No.
And commissioners from our side, that's about it.
Thank you, Ms. Ranto. Ms. Poroka,
No questions of clarification from
Thank
us,
you.
Chair.
from this side, Mr. Kuala.
We don't have questions for this witness, Commissioners. Thank you.
Yes, Mr. Koto.
Thank you, Commissioner. I do have a few questions of clarification for this witness. May I proceed?
Yes, you may.
Thank you, Commissioner. Advocate Nche, you, near the end of your evidence, you indicated that the speculation by Mr. Galata that you had been requested by Advocate Smelane to remove Advocate Ackerman.
No, it's not speculations from me. Speculation stated in the statement.
Correct.
Yes.
That is the speculation from Mr. Galata.
Yes.
Correct. But then you indicated that that speculation was not improper.
Yes. Correct.
Right. So now you said he had said in passing, why are you still keeping Ackerman there?
That's it.
Do you remember where he said this in passing?
Well, the where will be in the premises of the NPA in Silverton. But you remember I said I cannot remember the date and time. But it was not an issue said at the time or within a meeting or a discussion of the PCLU. He just mentioned it in passing to me because he used to call me chief. He just said, "Hey chief, why are you still keeping Ackerman there?" We were walking and that was it.
And could you, I don't know if you, the circumstances that would cause him to ask you such a question, he was DG at the time, am I correct?
Yeah.
So is this at the time when the DG's meetings were happening and there was all this acrimonious fighting, if I can put it that way, between, regarding Ackerman?
Yeah, that will be correct. And if I may add, in addition to that, I then recalled what Vusi Piccoli would report after attending the meetings of the task team, especially where the DGs would be present. That look, Ackerman abasamfuni. Yeah. So when he said it to me now in person, I recalled what Vusi Piccoli had told me.
So would you consider what the question as to why are you
Mr.
still...
Koto, I think your line of questioning is bordering on cross-examination. It's no longer clarificatory.
I understand that, Chair. I
Thank
think
you.
then I'll reserve those questions with for cross-examination. And then, okay, yes, just one more thing. Were you ever in any informal meetings with Advocate Smelane, possibly at airports or garages or any of those places discussing Ackerman?
Discuss Ackerman? No, not at all.
No, I have no further clarification questions. I will
Thank
reserve
you.
the rest for cross.
Thank you, Mr. Koto. Mr. Seminya?
Chairperson, with your permission, and in anticipation of the application by Weber Wenzel to cross-examine, we prefer to defer our questioning after answers to those cross-examination questions have been made.
Thank you. Mr. Salugazana, I dare say there is no re-examination pursuant to the clarificatory questions that have been posed to Advocate Mshe.
You are correct, Chairperson.
Thank you.
Are you intimidated?
No, not at all.
Advocate Mshe,
Madam.
we thank you for having made yourself available to this commission for your evidence. As you may have noted, there is an intention to apply for your cross-examination by several parties. Until that has happened, you may be recalled as a witness, but for now you are excused as a witness.
Thank you, Chair. Thank you, Commissioners.
Thank you.
Chairperson, I'm advised that the plan to have
Advocate Nsebeza.
Advocate Nsebeza and Mr. Kaji, we are unable to substitute Mr. Nsebeza with Mr. Kaji for tomorrow. He is not available. That puts our calendar in jeopardy somewhat. Consequently, we are unable to sit for Wednesday and Thursday. I'm corrected. We will sit on Thursday, which was, as per calendar, the evidence of Mr. Kaji.
Yes. So Mr. Kaji is unavailable tomorrow morning.
He is unavailable tomorrow morning in substitution of the evidence we otherwise would have had
Yes.
from Mr.
Yes.
Nsebeza.
Well, in as much as we are quite eager to proceed with our proceedings as we have scheduled, we have to postpone these proceedings until Thursday, the 9th of April at 10 hours for Mr. Kaji's evidence.
As the commission pleases.
These proceedings are adjourned. Thank you, Mr. Salugazana.
Thank you, Chairperson.